At 11:34 last night, Chief Justice John Roberts issued a statement that has never been issued in American history. Quote, "After careful constitutional review, I hereby decline to preside over the Senate impeachment trial. The Senate lacks constitutional authority to conduct this proceeding under current circumstances. I will not participate in what I believe to be an unconstitutional process. This is not a scheduling conflict. This is not a procedural dispute." This is the Chief Justice of the United States declaring that the Senate's impeachment power is invalid. And this has never happened in 235 years of American constitutional government. Subscribe to this channel immediately, because what I am about to walk you through is not political disagreement. This is the Supreme Court directly challenging Congress's most serious constitutional power. This is separation of powers and complete breakdown. Turn on notifications, because the constitutional crisis that began with presidential defiance has now escalated to judicial nullification of legislative authority. Here is what Roberts actually said in that statement, because the full text reveals the constitutional argument he is making. The statement was released at 11:34 p.m. through the Supreme Court's Public Information Office. Quote, "Article I, Section 3 requires the Chief Justice to preside when the president is tried. However, the current circumstances present constitutional questions that have not been resolved by proper judicial review. The Senate's assertion of authority proceeds from flawed premises. Until these constitutional questions are adjudicated through proper channels, I cannot in good conscience validate this process through my participation." That is the Chief Justice saying the Senate's impeachment is constitutionally illegitimate. Roberts is not claiming scheduling conflicts. He is claiming the entire proceeding violates the Constitution, and he is refusing to participate. At 11:47 p.m., 13 minutes after Roberts' statement, Senate Majority Leader Chuck Schumer held an emergency press conference. Quote, "The Chief Justice's refusal to preside is unprecedented and wrong. Article I, Section 3 of the Constitution is clear. The Chief Justice shall preside when the president is tried. This is not optional. This is not subject to the Chief Justice's interpretation of other constitutional questions. We will proceed with the trial with the president pro tempore presiding as allowed under Senate rules." But at 12:03 a.m., Senate parliamentarian Elizabeth McDonough issued a ruling that complicates Schumer's plan. Quote, "Senate rules require the Chief Justice to preside over presidential impeachment trials. No alternative presiding officer is authorized under current rules. The Senate would need to change its rules to proceed without the Chief Justice, and any conviction achieved without proper constitutional procedures would face legal challenges." Hit that like button right now if you understand what just happened. The Chief Justice refused to preside over impeachment. The Senate says it will proceed anyway. The parliamentarian says the rules require the Chief Justice. This is three branches of government in direct conflict over who has authority to determine impeachment procedures. The mathematics of this crisis are staggering. The Senate has 100 members. Under normal circumstances, 67 votes are required to convict. All 51 Democrats support conviction. The question was whether 16 Republicans would join them. But now the question is whether any conviction achieved without the Chief Justice presiding is constitutionally valid. If Roberts does not preside and the Senate proceeds with the president pro tempore, any conviction faces immediate Supreme Court challenge. The president's legal team would argue that conviction without proper constitutional procedures is void. The Supreme Court, led by the same Chief Justice who refused to preside, would likely agree. That means the Senate could vote 68-32 to convict, and the conviction could be overturned by the courts. The Senate's ultimate constitutional power becomes meaningless if the Chief Justice can nullify it by refusing to participate. Drop a comment right now. Tell me if you think Roberts has the authority to refuse impeachment trials. I am reading every response because constitutional scholars are debating whether the Chief Justice's duty to preside is mandatory or discretionary. At 12:34 a.m., House Speaker Kevin McCarthy, whose chamber voted to impeach, responded to Roberts' refusal. Quote, "The Chief Justice's statement is deeply troubling. The House exercised its constitutional authority to impeach. The Senate must exercise its constitutional authority to try. No single justice, even the Chief Justice, can nullify the impeachment power by refusing to fulfill his constitutional duties." But at 12:47 a.m., the president's legal team released a statement celebrating Roberts' position. Quote, "Chief Justice Roberts has demonstrated the constitutional wisdom and courage that we expected. This impeachment was flawed from the beginning. The Chief Justice's refusal to participate validates our position that the entire proceeding lacks constitutional authority. Subscribe to this channel right now if you have not already, because what I am about to show you is how this crisis affects the three-branch balance of power that has defined American government since 1789. The Constitution is explicit about impeachment procedures. Article I, Section 3, Clause 6 states, "The Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation. When the President of the United States is tried, the Chief Justice shall preside." The word "shall" appears twice. The Senate shall try impeachments. The Chief Justice shall preside. Both are presented as mandatory duties, not discretionary powers. Roberts is arguing that his duty to preside is conditional on the proceeding being constitutionally valid. But the Constitution does not give him authority to make that determination. This creates a constitutional paradox. If the Chief Justice can refuse to preside by claiming the impeachment is invalid, then he effectively has veto power over the Senate's impeachment authority. That would make the Chief Justice more powerful than the entire legislative branch on matters of presidential accountability. Here are the 6 indicators we are watching over the next 48 hours to determine how this crisis resolves. Indicator 1, does Roberts issue any clarification about the specific constitutional grounds for his refusal? If he provides detailed legal reasoning citing specific constitutional provisions or precedents, it suggests he is prepared to defend this position in lengthy court battles. If he remains silent beyond the initial statement, it may indicate uncertainty about the legal foundation or recognition that further explanation could worsen the constitutional crisis. Indicator 2, do any other Supreme Court justices publicly support or oppose Roberts' position? The court typically maintains unified silence on political matters, but this situation directly involves judicial authority. If conservative justices like Thomas or Alito issue supportive statements, it signals institutional backing. If liberal justices like Kagan or Sotomayor criticize the refusal, it reveals fundamental splits within the court about constitutional interpretation and institutional roles. Indicator 3, does the Senate proceed with the trial using the president pro tempore as presiding officer? If Schumer moves forward, it tests whether the Senate believes it can conduct valid impeachment trials without the Chief Justice. Indicator 4, does the president's legal team file immediate court challenges to any Senate proceedings? If they seek injunctions to halt the trial, it forces federal courts to rule on the Chief Justice's authority. Indicator 5, do constitutional law scholars reach consensus on whether Roberts' refusal is legally justified? Academic opinion often influences judicial decisions and public perception of constitutional disputes. Indicator 6, does Congress consider any legislative response to clarify impeachment procedures? If House and Senate leaders conclude that constitutional ambiguity created this crisis, they may attempt to address it through statute or constitutional amendment. The algorithm decides what breaks through. You decide whether people see this constitutional analysis, because what we are witnessing is the breakdown of assumptions that have governed American democracy for over 2 centuries. Here are the 3 scenarios for how this crisis resolves. Scenario 1, Roberts reverses his position under pressure. Facing criticism from legal scholars, political leaders, and constitutional experts, the Chief Justice issues a clarifying statement. He agrees to preside over the trial while reserving the right to address constitutional questions through separate proceedings. The impeachment trial proceeds with traditional procedures. This is the institutional compromise scenario where the crisis de-escalates through judicial flexibility. Scenario 2, the Senate proceeds without Roberts and achieves conviction. Schumer changes Senate rules to allow the president pro tempore to preside. The trial concludes with a 68 to 32 votes to convict. The president is removed from office, Roberts, and the Supreme Court face a choice: validate the conviction or overturn it. If they validate it, the Chief Justice's refusal becomes meaningless. If they overturn it, the Supreme Court directly nullifies a Senate impeachment conviction for the first time in American history. This is the judicial supremacy scenario where the courts ultimately control congressional power. Scenario 3, constitutional deadlock paralyzes the government. Roberts maintains his refusal. The Senate cannot proceed with valid impeachment procedures. The president remains in office despite House impeachment. The three branches operate in fundamental disagreement about their respective authorities. Future impeachment becomes impossible. If Chief Justices can refuse to preside, the constitutional system loses its ultimate accountability mechanism. This is the systemic breakdown scenario where separation of powers principles prove incompatible with modern governance requirements. Subscribe right now, like this video. Comment with your prediction about which scenario unfolds. I am tracking all three possibilities and will provide immediate analysis as events develop. Let me show you the historical context that makes Roberts' refusal unprecedented. In 1868, Chief Justice Salmon Chase presided over Andrew Johnson's impeachment trial despite personal opposition to the proceeding and despite believing that Congress was overreaching its constitutional authority. Chase later wrote that his duty to preside was absolute and unqualified by personal constitutional interpretation. In 1999, Chief Justice William Rehnquist presided over Bill Clinton's trial despite privately calling it a political spectacle, and despite constitutional scholars questioning whether perjury in a civil case constituted high crimes and misdemeanors. Rehnquist treated his presiding role as ministerial, not interpretive, in 2020 and 2021. Roberts presided over both Trump trials, despite constitutional questions about trying a former president in the second case and despite unprecedented procedural disputes. Even when senators questioned his rulings during the trials, Roberts maintained that his role was to facilitate Senate procedures, not to judge their constitutional validity. The pattern across 150 years was clear. Chief justices viewed presiding over impeachment as a constitutional duty separate from their judicial role. They acted as presiding officers, not as constitutional arbiters of the proceedings themselves. Roberts is breaking this precedent by claiming authority to judge impeachment validity before agreeing to participate. This breaks 150 years of constitutional precedent. If chief justices can refuse impeachment trials, then the Senate's sole power to try impeachments becomes conditional on judicial approval. That fundamentally alters the balance between legislative and judicial branches. At 1:47 a.m., former Attorney General Eric Holder issued a statement calling Roberts' refusal a constitutional crisis. Quote, "The Chief Justice does not have authority to determine whether impeachment proceedings are valid. That determination belongs to the House when it votes to impeach and to the Senate when it votes to convict. By refusing to preside, Roberts is claiming power that the Constitution does not grant him." But at 2:15 a.m., conservative constitutional scholar Stephen Calabresi defended Roberts' position, quote, "The Chief Justice has institutional obligations to protect constitutional processes. If he believes the impeachment proceeding violates fundamental constitutional principles, he has not just the right but the duty to refuse participation rather than validate an illegitimate process." What I know for certain right now at 11:34 p.m. Chief Justice Roberts refused to preside over presidential impeachment for the first time in American history. He claimed the Senate lacks constitutional authority under current circumstances. Senate Majority Leader Schumer announced the trial will proceed with alternative presiding officer. The parliamentarian ruled that Senate rules require the Chief Justice to preside. The president's legal team celebrated Roberts' refusal as validation of their constitutional arguments. Republicans split between supporting Roberts' constitutional concerns and opposing his unprecedented refusal to fulfill constitutional duties. This is separation of powers reaching maximum tension with international implications. The legislative branch claims exclusive authority over impeachment procedures. The judicial branch claims authority to determine whether those procedures are constitutionally valid. The executive branch benefits from the conflict by avoiding accountability, and foreign allies are questioning American constitutional stability for the first time since the Civil War. The mathematics remain stark, but now include judicial variables. The Senate needs 67 votes to convict, but any conviction without proper constitutional procedures faces Supreme Court nullification, even if 16 Republicans join 51 Democrats for conviction. The same Chief Justice who refused to preside would likely lead a court majority overturning that conviction. The Senate's ultimate constitutional power becomes meaningless if the judiciary can preemptively nullify it through non-participation. The next 48 hours will determine whether Roberts maintains his refusal, whether the Senate proceeds anyway, and whether the Supreme Court ultimately validates or overturns any conviction achieved without proper constitutional procedures. Turn on notifications when Roberts issues any clarification, when the Senate takes action, when the constitutional crisis escalates or resolves. You will see the analysis here immediately. This is not over. This is the Constitution's accountability mechanisms breaking down in real time. And what emerges from this breakdown will determine whether American democracy includes effective checks on presidential power or whether we have learned that constitutional processes only work when all three branches agree to follow them. The constitutional crisis has reached the Supreme Court. Democracy's ultimate test is whether the rule of law can survive when the law's highest interpreter refuses to enforce the Constitution's most serious remedies.